Welcome, everyone. Welcome to this timely expert discussion on access to justice at the intersection of disability and older age. My name is Nena Yoranzi, and I'm Policy Coordinator at Age Platform Europe, which is the largest EU network of organizations of and for older persons. This event is being recorded and is being webcast live on webtv.un.org. The link to the captions can be found in the chat box. Please email Erin Harding, whose mail is also found in the chat box, if you have any questions about this along the way. We have the honor to have with us today Mr. Hans Almoslechner, Deputy Permanent Representative from the Permanent Mission of Austria to the United Nations, who will provide some opening remarks. To give us all of an idea about the flow of events, this event will then be divided in two segments. We will have a moderated discussion with Ms. Claudia Mahler, the UN independent expert on the enjoyment of all human rights by older persons, and Mr. Gerard Quinn, the UN Special Rapporteur on the rights of persons with disabilities. Then we will have a question and answer period among all of us attending this side event. Congratulations both to Claudia and Gerard for the recent appointments by the UN Human Rights Council. Please feel free to put your questions in the chat box at any time, and we will address them during the second segment of the side event. Mr. Almoslechner, you have the floor.
Thank you very much, Excellencies, ladies and gentlemen, dear colleagues. It is my pleasure to welcome you on behalf of the Permanent Mission of Austria to this side event, Access to Justice at the Intersection of Disability and Older Age. This event has been organized by our partner, the International Disability Alliance, and I'm glad that Austria co-sponsors it with our colleagues from the Help Age International, Age Platform, UNHCR, UNDESA, and the NGO committees on aging in Geneva and New York. The right to access to justice for all forms an important basis for strengthening the rule of law through the administration of justice, an important topic for Austria that we continue to work on with our resolutions on human rights and the administration of justice at the Third Committee of the General Assembly and the Human Rights Council. Last year's resolution in the Third Committee specifically addressed the situation of persons with disabilities in the administration of justice, and among others, and I quote, called upon states to take effective and appropriate measures to remove all barriers preventing persons with disabilities from having effective access to justice on an equal basis with others and without discrimination. Access to justice for older persons also has a strong tradition in Austria. With the Senior Citizen Council, Austria has established a federal consultative body representing the interests of older persons and their non-governmental organizations towards the government. This institution, by law, takes part in parliamentary discussions and offers advice and guidance for decision-making. Austria's National Action Plan on Disability 2012 to 2021 also devoted a chapter to older persons with disabilities. One priority of the work on the next National Action Plan is to raise awareness on the drafting process and to increase the participation by various stakeholders. In this regard, the new National Action Plan on Disability 2022 to 2030 is currently being developed within a broadly based participation process with all stakeholders, ensuring that all voices are heard. The current pandemic has exposed and often exacerbated existing inequalities that affect older persons, especially older women and older persons with disabilities, and persons with disabilities of all ages. It is therefore timely to address abuses to their right to access to justice and discuss how we can build back better. I'm looking forward to today's discussion with UN independent expert on the enjoyment of all human rights by older persons, Ms. Claudia Mahler, and the Special Rapporteur on the rights of persons with disabilities, Mr. Gerard Quinn. I thank you and wish you a fruitful discussion.
Thank you very much, Mr. Almoslechner, for your support to this event and these opening remarks. And of course, you have provided us with a very interesting frame, an important frame, just highlighting how broad the right to access to justice is, and it expands well beyond its judicial aspects. So let's turn to Claudia now. Claudia, what does access to justice mean for older persons, and why is it important for the equal enjoyment of their human rights?
Thank you, Nena, for the question. And also let me, first of all, thank all the organizers for inviting me. And I also want to wish you all a good morning, good evening, and good afternoon. I was really delighted when the organizers asked me if I would like to join an event to have a conversation with my colleague, Gerard, the Special Rapporteur on the rights of persons with disabilities. I can tell you why. I'm looking forward to this meaningful exchange. First of all, I'm always jealous because he has a wonderful advanced legal binding human rights convention, which gives him a powerful framework to advise governments how to improve the situations of persons with disabilities. And secondly, I'm always grateful that he can give us advice how we can achieve the goal to get better protection for older persons. For using the tools we have included the CRPD in the most effective way, and to lobby for a comprehensive legal binding instrument to close the remaining gaps. Gerard has been a part of the success story of the development of CRPD and can give us valuable hints how to realize our vision. But coming back to the question, access to justice and legal assistance are essential to achieving an age-friendly society where older persons are valued and respected as participating actively in society. I very often heard from governments that access to justice is a basic principle of the rule of law and does not need to be specified for older persons because they already have equal access to justice. But the paper prepared by OHCHR gives us relevant evidence that governments, civil society organizations, NHRIs and UN organizations identify deficiencies and barriers which hinder older persons to fully enjoy their access to justice. We need to be reminded that it is a relatively new concept in the human rights framework, which has been spelled out in a broader sense for the first time by the CRPD. Access to justice is a crucial cross-cutting right that enables rights holders to exercise all their human rights. Access to justice involves access to the mechanism of protection, redress, and remedy. It involves to seek and provide justice in all roles and contexts. The narrow concept of access to justice is about accessing legal representation in order to access legal system and outcomes. Traditionally, these rights generally guarantee equal access to an independent and impartial process and the opportunity to receive a fair trial when the individual's liberty or property is at stake. But from my perspective, it needs to be seen as a broader concept. We need to integrate access to information and access to services and legal representation. Access to justice involves inclusion and participation in mechanisms and processes of justice at all levels. I hope this was a long answer to your question, but it spelled out a little bit how broad the concept of access to justice is.
Absolutely, and I think this is essential for our discussion today in terms of thinking it in this cross-cutting way, and just how important access to justice is not the right per se, but really a prerequisite for the equal and just enjoyment of all other human rights. And like you, but also Mr. Almos Lechner mentioned before, it is about equal participation to society. And thank you for spelling out also some of the particular elements of this right when it comes to older persons. So Claudia, you also briefly mentioned in your answer that older people face specific barriers in terms of their access to justice. So would you like to expand on what you see as this barrier in your work as independent expert, and what it would look like if this would right to be equally realized for older person? How would it change in this and address these barriers?
Yeah, also not an easy question, but I will do my best. Ensuring access to justice requires not only effective remedies, but also enhanced awareness by older persons of their rights and the available of legal aid. Older persons require access to legal services, and legal information is crucial for them to be able to exercise their human rights. It is also essential that the specific needs of older persons in terms of accessibility, for example, as a barrier, be adequately taken into account. Measures in this regard should include preferential treatment of older persons in judicial proceedings, the provision of adequate information in an age-friendly and easy understandable manner, and the removal of physical barriers in court buildings is also needed. It is also important that members of the judiciary receive training on the rights of older persons and to be able to bear in mind the diversity of older persons and the intersectionality of the group. We have also seen during the pandemic that the crisis had an impact on the right to access to justice. The pandemic has had an unprecedented effect on the functioning of the judicial system. Courts were closing, are reducing or adjusting their operations, which can negatively affect the provisions of timely and fair hearings, contribute to increased case backlogs, and lead to longer judicial administrative proceedings. Older persons must have access to legal information and an understanding of the court procedures in order to realize their rights. If access to justice is available on an equal basis, then older persons would have unhindered access to all stages of proceeding. For older persons, it is not easy to case a file. It is vital for them to ensure that they can receive the necessary legal support, especially if they do not have enough resources to pay for them. Older persons need to be empowered also to use the digital technology, including video conferencing facilities, and to communicate by telephone or with Messenger's app to enable them to adhere to physical barriers or distancing measures, what we have seen in the current crisis. Procedural accommodation need to be made for older persons, in particular those with disabilities. In many crisis contexts, connectivity and access to the internet may be limited, and there is often a clear gap in the digital access affecting older persons. I always had the idea that it might be crucial also to establish an independent and impartial entity, procedure, or body, possible within an existing independent body with the mandate to examine complaints pertaining to older persons. It is also important to apply the jurisdiction of an independent body, such as an ombudsperson or an optional protocol to the Convention Against Torture or other cruel, inhumane, or degrading treatment or punishment, and to consider its specific application to guarantee safe care for older persons, including in residences for dementia, for persons with dementia. I would say the legal safeguards and oversight mechanism must be in place to ensure that any derogation from or restriction or limitation of rights does not continue to identify and that states protect and ensure the enjoyment of all human rights by older persons. Barriers which are very often mentioned for older persons are ageism, age discrimination, financial disadvantages, inadequate social security, the lack of expeditious justice system, social, digital, and financial exclusion, lacks of expertise, restricted access to legal assistance, also power imbalance in modes of the representation, and those are also including the loss of autonomy and independence. All these barriers needs to be overcome to ensure that older persons can enforce their rights. Thank you.
Thank you, Claudia. And indeed, it's not an easy answer, but you did manage to give us quite a far-reaching, let's say, scene in terms of those barriers that have also been highlighted in all the inputs that we have received for this 11th session, identifying challenges, including, like you said, physical access, lack of reasonable accommodation, lack of affordability, delays, impact of digitalization, of course, cultural norms, and ageism. We'll hopefully have the opportunity to delve more into depth into those during our discussion. Now, Gerard, you have been involved both in the drafting and negotiations of the Convention on the Rights of Persons with Disabilities, the CRPD, and of course its monitoring and implementation. So I would like to ask you, in your views, how has the CRPD had an impact in terms of changing states' laws and improving persons with disabilities' access to justice?
Thank you very much, Nina. And like Claudia, I'd like to thank the organizers and the permanent representation of Austria for putting on this really interesting space today. I'd just like to make one or two preliminary points before I get to the impact of the Disability Treaty and the potential impact of a treaty on the rights of older people. First of all, I'd just like to say that the intersectional approach is extremely welcome. To me, it means that we're acknowledging that identities are very fluid. We're not born or stuck with one particular label. It also is an occasion to ask deeper and more probing questions. For example, what does ableism share with ageism? What kind of levels of exclusion do both of them trigger? And third, but most importantly, how can we imagine sustainable solutions across the life course, across identities, that's actually of service to states as well as to individuals? What is the point of advancing community living for people with disabilities if it's not at the same time advanced for older people? What can one arm of the state do in ignorance to the other arm of the state? How can we make systems work a lot better? I think it's also important from my point of view to realize that access to justice is not an end in and of itself. It's actually a portal to other things. And the most fundamental of these is recognition as a person, that you can use the law both as a sword and as a shield. As a shield in order to be able to fend off others, whether private parties or emanations of the state, and to use it as a sword in order to effectuate your own choices in the world, so that to have the world respect and honor your autonomy and your dignity and so forth. If the deck is stacked against you, if either ableism or ageism weighs down the scales of justice, then that's not only bad in and of itself in terms of accessing justice, but it makes it less likely that your full spread of human rights that you notionally enjoy as a human being will you actually be able to equally enjoy. So it really, really is important to have access to this portal, both substantively and otherwise, because otherwise the full spread of rights is rendered illusory and not actually real. And I think, as Claudia was intimating, that there are many, many different ways in which both ableism and ageism weigh heavily on the scales, not only in the criminal process, but also in the civil process. We have a very detailed list of international principles and guidelines on access to justice for people with disabilities, issued last year under the aegis of my predecessor as UNSR. This would not have been possible were it not for an article in the Treaty on the Rights of People with Disabilities on access to justice, a very innovative provision. So the treaty provision was a trigger that enabled people to ask the right kinds of questions about what is the impact of ableism on the legal process, what are the particularistic barriers, whether they're process-based or substance-based, or have to do with more general rights of access, for example, to legal representation, and how can we reverse them? So to me, the convention was the absolute trigger to enable those deeper questions to be asked. And hopefully the guidance given to states is very concrete in these provisions. I'm sorry, that was a very long-winded answer. Back to you, Nina.
No, I think that was, again, very, very important in terms of kickstarting this discussion and showcasing those both conceptual and procedural and substantive aspects of the right to justice, and how a convention can really be a trigger, like you said. So, Gerard, you mentioned in the beginning also the aspects of intersectionality, and you started discussing ableism and ageism. So how do you see this intersection between ableism and ageism playing out in terms of barriers to access justice for older persons with disabilities more specifically?
Yeah, I think there's an uncanny similarity between both, and what I mean by between both is in terms of the concrete obstacles experienced both by older people and people with disabilities in both the criminal process and in the civil process. For example, in the criminal process, both older people and people with disabilities have their testamentary capacity put in doubt or in jeopardy. The probative value of their word tends to count for less. They're not taken seriously as quote unquote reliable witnesses. They're not taken seriously as victims of crime. And the police are relatively insensitive to the difference of age and disability. That is by no means to blame the police. That is simply the legacy that we're left with. In the actual process itself, people with disabilities, and indeed a lot of older people, find the legal process off-putting. It's not accessible. It's not accessible to the average man on the street, let alone an older person or a person with disability. Even the symbiotics, the symbolism of the justice system is rather disquieting in terms of the architecture of the buildings, the sheer inaccessibility of these buildings. The rules and practice of procedure tend to make very little allowance for the difference of age or the difference of disability. And indeed, the substance of the law may be rigged against, subtly, not ostensibly, but subtly rigged against older people and people with disabilities. And if you're looking at the kind of outcome of the criminal process, there are no diversion programs for older people, or very few, or people with disabilities. There's very little acknowledgement of ongoing needs, very little reasonable accommodation, for example, in prison systems. There's no consciousness that an older person or a person with a disability are going to face additional difficulties in reintegrating into society. And indeed, in the civil process, very little is done to enhance legal literacy amongst older people and people with disabilities. There's limited availability of legal aid in order to pursue claims, and there may be some positive deterrents in going to court. For example, after COVID, we've seen a lot of problems with respect to services for people with disabilities and older people. We've seen a lot of problems in terms of unequal treatment in the healthcare system. And we've seen a lot of problems in terms of institutionalization. It's the deterrent of going forward to sue an entity like a service provider on whom you're going to have to rely makes it incredibly important, as Claudia said, that we think through the system, the ecosystem. We cannot rely exclusively on individual suits. We have to create space for class actions. We have to create space for actio popularis. We have to create space for independent entities like national human rights institutions to, as it were, take up the case of people whose voice is diminished, like older people and people with disabilities. And indeed, in the civil process itself, there is very little difference, allowance made in civil procedure for people with disabilities or older people. And sometimes the discovery process is extremely intrusive on the private lives of older people and people with disabilities. So whatever way you cut it, ableism and ageism wear down very heavily on the legal process. And I keep coming back to the fact that at least we had the trigger of Article 13 in the Disability Convention to begin asking the right questions, which of course is a precondition to putting in place the right kinds of policies.
Thanks, Gerard. And I think that there are many important points there, but what I'm taking out also as well is that ableism and ageism, they intersect, but they're also distinct on the one hand, and they need also different responses, but also different questions in terms of reframing our policies and our systems. But also it is important to highlight this idea that intersectionality is not just 1 + 1 = 2, but 1 + 1 may equal 10 or more. So combined ableism and ageism produce unique and qualitatively different forms of discrimination than the simple addition of the separate discrimination grounds. And so it can be even more grave than actually one distinct form of discrimination. Claudia, you mentioned before different ways in which you feel that existing guarantees need to be expanding to address some of these practical and legal challenges that you mentioned. But how do you feel that the convention can help address these and to better protect the right of older persons, including older persons with disabilities, to access to justice?
Thank you, Nina, for the question. And thank you, Sharon, also for pointing out the intersectionality. And I think part of the answer was already said by Gerard, because CRPD is a legal basis, especially for older persons with disabilities. So here we already have some kind of legal basis and a binding convention, but not all older persons are part of CRPD and are protected by CRPD, only those with a disability. And therefore, I think we also need to think out loud how we can achieve a better protection to overcome all the barriers we mentioned just before. And from my perspective, a dedicated normative instrument of the human rights of older persons would still give the highest protection and give us a real basis to further engage and spell out how the judicial system needs to be improved. And what we have seen is that the current system still have there many conceptual limitations in the existing instruments. And from my perspective, they also appear to be the primary reasons for the barriers, which we have already described before. And the adoption of such a dedicated instrument is also the most effective way to bring about a major change, which is already required from our perspective. Have said that, is that we also need to include older persons in their capacity as experts. So what are the most insufficient legal systems we have seen, and how can we improve them? We already have some kind of basis in regard of the regional systems. We have the Inter-American Convention on the Rights of Older Persons, which can be a basis for further discussions, but from my perspective is still not sufficient in this regard. And this is also true for the African Protocol. And another tool which we can take into consideration is the non-binding recommendation of the Committee of Ministers of the Council of Europe, which includes also specific elements we should discuss and have a different argumentation and aspects than the other regional instrument of the Inter-American Convention. So from my perspective, this is a great starting point in regard of trying to figure out how a specific article on the rights of older persons and their access to justice should look like. We need to overcome the barriers, and it would be a perfect basis to spell out how we can improve the system. And I would say that already CRPD, or the Convention on the Rights of the Child, showed us that a specific human rights instrument with a specific perspective on also the right to access to justice gave the states good guidance how to improve the system. Thank you.
Thanks, Claudia. And this is what you mentioned is really highlighted indeed in the OEWG report in terms of the international human rights treaties and treaty bodies not having specifically addressed the barriers facing older persons in terms of accessing justice. And the working document for this open-ended working group also mentions lack of knowledge and awareness as a significant challenge, both in terms of older persons who may not know about their rights and how to claim them, but also in terms of judges and staff in the justice system. And this is something that both you and Gerard mentioned in terms of the need to train judges and staff about access to justice and specific barriers by older persons and persons with disabilities. But however, I would like to turn to this idea of lack of awareness and knowledge of older persons and persons with disabilities themselves. So how can a convention help not just by solving legal claims, but really supporting rights holders and the organizations that represent rights holders in accessing justice?
Is this a question to me or to
Both
Gerard?
of you, I would say,
Okay.
both of you from your specific perspective, and Gerard, perhaps from the experience of the CRPD.
Thank you, Nena. So maybe I just start because we are not having a convention, and so it's just thinking out loud how our perfect vision would be. And I would say that a convention would really raise awareness and give specific guidance, not only the states, but also the different stakeholders, how to ensure that they make their enjoyment of all their human rights possible and judicial working. And I would say it is much easier for an older person of a person with disabilities to reflect on a convention which have a specific focus on the group, because there they find their own specificities, their own needs and their own perspectives. Because what we have seen is, which you already mentioned and which is also spelled out in the paper of the OHCHR analytical update, that the current system, the treaty bodies, don't have the means to address all these specific aspects, and also older persons don't see themselves as part of those conventions, and so they are not using the system. And what I said in the beginning, you know, when we discussed access to justice with some states representatives, I very often heard there are no barriers. They have the same access to justice as everybody else. But when we have a specific look on other treaties, we see that there are barriers, and we see them also in the OHCHR paper. So also the states refer to the barriers they are seeing by themselves. And also Gerard already told us, these are the buildings, these are in the brains, these are in the system. So we have many different barriers, and I would say that a specific convention which has a specific focus on older persons is the perfect tool to raise awareness and to make a meaningful change. Thank you.
Thank you, Claudia. Gerard, is there anything you would like to ask, to contribute from the perspective of the CRPD, perhaps?
Yeah, just 2 or 3 quick points. I happen to be rereading a lot of the Council of Europe documentation recently, and I'm struck by 1 or 2, including Committee of Ministers, who expressly say there are no normative gaps, there are just implementation gaps. And having said there are no normative gaps, there is a normative discounting. There always is a weighting of people with disabilities or older people in existing systems. And that seems to me to be the major problem here. And in terms of a treaty provision, a global treaty provision, by the way, there are some calls for a Council of Europe thematic treaty on the rights of older people. I think we'll probably see a UN treaty before we see a Council of Europe treaty. But it's important to realize that these treaty provisions in and of themselves are not self-executing. They don't give you granular answers to particular questions, but they help you completely reframe how you ask the right questions and how you seek solutions. And so I think there is a very direct causal link between the existence of Article 13 in the CRPD treaty and then the further elaboration of the very detailed standards on access to justice for people with disabilities adopted last year. That would not have been possible without the trigger of Article 13 of the Disability Convention. Now, I would see ableism and ageism working out slightly differently in terms of the particular obstacles faced and therefore the particular solutions required. There'll be a lot of overlap, but there'll be a lot of discontinuity as well. And one of the hidden byproducts of adopting a universal treaty is that that then triggered a lot of change around the world in terms of judicial training, the training of lawyers. For example, Europa Rex Academy in Trier has for years been putting on courses specifically for European judiciary in what to think about the CRPD, how to accommodate it into their work, and then to think through the barriers people with disability faced within how they operate within the legal system. And that's been quite transformative. It's a slow burner. It takes a long time for legal culture to change, but at least we had that trigger, and at least it started those processes of self-reflection amongst the professions, the legal profession included. And without the trigger of Article 13, hand on heart, that would not have happened.
Thanks, Jared. And I think this comment even goes perhaps beyond the specifics of access to justice when it came to the CRPD and the frame that it provided. And one of the issues that at least I see in my work in terms of a barrier to access to justice is not the legal proceedings per se. It is the legal proceedings, but it's not only the legal proceedings. It's also the lack of a legal framework. When we lack an explicit prohibition of age discrimination in all areas of life, when we accept justifications in terms of age discrimination more largely and more easily than for other forms of discrimination, when we lack the same standards in terms of the right to live independently in the community for older persons compared to other parts of society, other groups in society, then we have really what we see is ageism embedded in the laws, embedded also therefore in the legal system and in the case law as we see coming out of these laws that we try to apply. So I guess that what you're saying in terms of the CRPD providing this frame that allows us to analyze and ask the right question and seek different solution has to do with that, right? And it's not specific to access to justice as a right, but really to the full enjoyment of rights.
Yeah, I'll be very brief because I know time is of the essence. But one of the big difficulties with ableism has been a very subtle problematization of the person. If you can't live in the community, maybe it's something to do with you. So it stopped people asking the deeper questions. What is it about social arrangements that make it impossible for you to continue living in the community? I think we've largely dealt with that in the Disability Convention. The Disability Convention is about uncloaking the person behind the mask and de-problematizing the person. I still think that older people are still problematized, even in the language we use, even in policy documents. Even if you look at some Council of Europe instruments, they say you have a right to live aging in place for as long as is possible, or as long as you wish. Of course, your actual desires are very much shaped by the architecture of choice you face in your life. And in any event, it takes the focus off where the intention should be, which is what is the quality of the supports we put in place to enable you to live longer in your community. So it's the problematization of people that we're trying to reverse.
Thanks, Gerard. And Claudia, you mentioned that you received this question in terms of, the existing system is enough. And sometimes specifically, we hear that also about the CRPD in terms of, implying basically that the barriers that face older people have primarily to do with the increased risk of developing disabilities. So how do you react to that? And we have had some questions in the chat that go into that direction, saying that, how to best include older people in the mechanisms of the CRPD, but also how to ensure that the differing needs of those aging into disability and those aging with disability are including. Can you tell us what would be the tactic that we can use in terms of addressing some of these arguments that we hear a lot about older persons and people with disabilities overlapping too much and the CRPD being an inadequate framework? What are your thoughts on that?
this is also a tricky question because we are also relying on CRPD to make it a good model. And we all know that some of the problems we see right now that CRPD was so powerful. So many states and governments don't want to have a same perfect human rights instrument which binds them to implement the human rights much better and get better guidance for them. But what we always need to spell out that there is a group which also gets support and protection from CRPD, older persons with disabilities, that's for sure. And it's very good that they can apply to the protection of the convention. But there are many older persons who are not part of this group. And for them, we need to have a specific protection and see quite clearly what are their barriers and where do they need support. As Gerald also mentioned, you know, it's still not a person-centered approach. What we have witnessed through COVID-19 was ageist and ageism in all different aspects. You know, it was spelled out in the media. It was spelled out when it came to different political agendas. And I think people have not been aware at the first stage that this is real ageism and that this is a barrier for the enjoyment of all human rights by older persons. But to be honest, I think we specifically think a little bit about what is really needed. One thing is time. Time is essential for older persons, so short proceedings are in need. Then what we have also seen already is support in regard of understanding the judicial system and getting legal aid. From another thing from my perspective is also to understand their human rights and to get more support in this regard. And the question of language is also quite critical and key in this regard. We have seen so many different approaches which don't consider that it's not easy to understand how to get access to the proceedings and where do they get the information which is timely and is it really effective for them. As Gerald already spelled out, it is more like a burden to go to the court and try to get their rights in practice, because in the end it might not work out for them. And these kind of aspects are big barriers for them, and we need to address them step by step and also consider and consult with older persons in their sense. What is their major obstacles in this regard? We can only do it as a practical consultation with meaningful participation of older persons to find out exactly how we can achieve a better solution in this regard. Thank you.
And Jared, and how have you, thank you, Claudia, and you have identified all those particular obstacles for older persons that are not adequately covered by the CRPD. But as I was speaking, I was thinking that perhaps Jared has something to add on that in terms of how you have perhaps responded when you were drafting the CRPD in claims that, you know, the system is already sufficient and we do not need anything more. You know, there are no normative gaps. This thing that we keep on hearing. I understand that you dealt with this in a different way when you were drafting CRPD, right?
Well, we weren't confronted with the argument that perhaps we will move forward if you can establish there are some normative gaps. That really wasn't the question of the day. It was assumed by all that rights being universal, the normative gaps either didn't exist or existing norms could be stretched to encompass the situation of people with disabilities. The real problematic was the implementation gap, that ableism had kind of weighed down the otherwise universal principles and diverted them or diverted attention, and that there was no deep logic to the norms, that they weren't stretched by the relevant organs to actually reach the particular situation of people with disabilities. So in one sense, the task facing the drafters was a very mechanical one. Where are the implementation blind spots, if I could use that word politically incorrectly? What accounts for the particular blockages in those areas? How do they impact on the equal effective enjoyment of the otherwise universal right? And then what kind of general and particular obligations are necessary to reverse or to boil away those obstacles? And I think mechanically that's the task that would face the drafters of a treaty on the rights of older people, not so much the generalizable obligations, because they can be crafted by analogy from the other conventions, but the very particularistic obstacles and how they could be reversed using very specific obligations, bearing in mind that a lot of obligations will be obligations of progressive achievement, and there's plenty of space there for states to sign on board. And I always say that the absence of voice of persons with disabilities and older people during the initial stages of reacting to COVID was not even in the interests of states, because the problems that emerged were completely predictable and could have been predicted if the right voices had been at the table. So this is not something that acts as a side constraint on state practice. This is something that enriches and informs state practice for the benefit of everybody.
Thanks, Gerard. And this is also highlighted in the OEWG report in terms of this invisibility argument. It's not about the existing standards equally apply, of course, to older persons, but the particular violations that they have been facing are not necessarily as visible in the existing system.
Exactly.
I want to bring forward a question that we have received from Bridget Sleep, saying, could you talk about the value of a new convention clarifying that older people's legal standing and legal agency is guaranteed on an equal basis with others and cannot be denied on the basis of older age alone or in combination with other factors, just as the CRPD does for disability? Either of you, whoever wants to take the floor.
Now you can start, Gerard, if you want.
Yeah, I think this is fascinating because, one direct implication of ageism is almost the cultural assumption that through time, your capacity to navigate your own life, to make decisions for yourself is quote unquote naturally eroded. So even where the law doesn't intrude or doesn't take away your autonomy or your legal capacity, third parties, maybe family members, informally assume that they have that power and that right over you, not only your property, but also your personal choices and personal destiny. So to me, one aspect of reversing the invisibility is to restore the ingredients of competent decision-making. And if they're not fully there, find ways to augment them rather than to use it as an occasion to take voice away. It always struck me as odd that if there were some weaknesses with respect to you expressing your voice, that those weaknesses would be used as an occasion to take voice away completely. In fact, the reverse should be the case. We should be inquiring, what do we need to put into place in order to enable you to continue to make the decisions you make for yourself? And actually, some of the smaller ones are the more important ones over time, like when to go to bed or what kind of breakfast to have and so forth. So I think there's a very strong unity of purpose between the autonomy provisions in the CRPD treaty and hopefully the autonomy provisions that will be in the Treaty on the Rights of Older People.
Thank you, Gerard. I think I would like to add one more thing. We very often hear the excuse in the best interest of the older person. So I remember also that we had this discussion when we discussed legal capacity in regard of older persons in the Council of Europe's recommendations. And we always heard that there need to be some protection because of the best interest of older persons. So this already implies that the older person is not capable of to do their own, to make their own decisions. And it was not thought, as you already said, how can we assist this kind of process to make their decisions heard, their own ideas spelled out, if this is just a problem. And I fully remember that this was one of the major points we discussed during the drafting of the recommendations. And I still think we didn't overcome these kind of negative images of older persons. And still we see CRPD did also trigger this discussion. But from my perspective, we did not really overcome these negative images that older persons are not rights holders till their end. They are still seen as beneficiaries in the system. And I think this is something we really need to change. And therefore, a convention would be the major instrument to change these narratives in this regard. Thank you.
Thanks to both of you. We are receiving a lot of questions in terms of this intersectionality and how it can be addressed through the CRPD and the new convention. And a specific one is from Sanna Ahola from Finland, in terms of, should a specific convention then include articles and provision regarding I guess, disability and functional capacities or functional limitations of older persons, or rather try to use the provisions of the CRPD here in order to address this intersection? How to go about doing that? And that is an interesting question, especially bearing in mind that we do not have in the CRPD an article on older persons with disabilities like we have for women and children, for instance. So how do we address the overlap without reinventing or perhaps putting into question existing standards? How should we go about doing that?
I think the main question from my perspective is that we need to ensure that we don't lower the standards. And you already said that we don't have a specific provision in regard of older persons with disabilities. So we need to address the intersectionality if we ever get a new treaty, because I think this is key for all of us, and also to show directly what this means for older persons and also the diversity of older persons. And as I already said, you know, we really need to ensure that the standards are not lowered in this regard. And therefore, I think we need to work closely with the colleagues of the CRPD and ensure that we are enforcing the rights in the best way.
Jared, is there anything you would like to add before we move into the Q&A?
Yeah, just two very quick things. When we started drafting the Disability Treaty, we thought it would just be an equality of opportunity tract or a non-discrimination tract. What we quickly discovered, pushed by civil society, was that the reason we have these unequal treatments in various domains, education, transport, is because of lack of respect for personhood. So I think the personhood and autonomy and human agency issues should be front and center in any treaty on the rights of older people, because that's the most direct way of trying to reverse the problematization of older people. I remember being present during the drafting of the Disability Treaty, where somebody was making the argument that older people should receive more prominent mention, but it was only one person in a room of about 200. And so the agenda quickly crowded over that. And it was simply down to the lack of having voices in the room. I remember thinking to myself, that's wrong, will we pay a price for this? And I was totally right. The convention makes a stab at intersectionality. It just opens the field, but it doesn't explicitly include, for example, Indigenous persons with disabilities or older persons with disabilities. That's not to preclude the committee developing that jurisprudence. which in fact it is doing, but it would be much better if the Treaty on the Rights of Older People, right from the get-go, adopted a very intersectional approach. And I don't see any negative implication of the Treaty on the Rights of Older People, including a specific article on older people with disabilities. And in fact, I see a lot of positive bridges that can come from that, intersectional bridges between both instruments and indeed other instruments as well.
Thank you, Jared and Claudia. I will now move to the Q&A section. So I would like to ask those of you who want to take the floor to raise your hand by using the participants tab, which is at the bottom of the list of participants. And we have already received a request for the floor by Ms. Laura Mills. So would you like to take the floor and make your comment or ask a question?
Hi, thank you. Can everyone hear me? Okay, well, thank you so much to the independent expert and the special rapporteur for this very interesting discussion. My name is Laura Mills. I am a researcher at Human Rights Watch, currently working on older people's rights. Last week, we published a report about neglect and abuse of nursing home residents in the United States during the pandemic. We documented several really horrific cases, including severe weight loss, dehydration, infected bed sores, and some leading to death. We documented substandard hygiene and widespread physical, mental, and emotional decline. And the report points out how short staffing combined with the absence of family visitors to create a sort of perfect storm in terms of negative or poor quality of care. In addition, nursing homes became very untransparent during this time as monitors and advocates were largely locked out. Unfortunately, despite all of this, more than 30 states in the United States have passed measures that prevent people from filing lawsuits against facilities for any concerns, even tangentially related to the pandemic. In fact, just this week, we are learning of yet another state, Arizona, that is trying to do this. These laws are often broad and they protect facilities in cases of neglect and abuse as long as they're somewhat related to the pandemic. It was already, as I'm sure you know, very difficult for nursing home residents and their loved ones to access justice before the pandemic, but it has become nearly impossible in many places now. So I would just sort of like to open with a question. You know, in terms of institutionalized people already have such limited avenues to accessing justice, institutionalized older people as well during the pandemic and beyond. What do you see as the solution when it comes to ensuring that older people with disabilities in institutions have access to the courts? Thank you.
Thank you, Laura. If that's okay for Claudia and Gerard, shall I take a couple more questions, no more than that, and then I allow you to respond to all of them. Kieran, would you like to take the floor? Kieran Robert from ILC Canada and the Global Alliance. Kieran? Can you unmute yourself, or should we?
Okay, is that better? Can you hear me?
Yeah, yes. We can hear you.
Sorry,
No
I'm on my iPad and I couldn't find the button. Thank you so much for such a rich and timely discussion. Nina, fantastic job. Claudia, Jared, thank you. I have a very simple question. You probably can guess my question. I just want you to make a couple of quick comments about the availability and access for older persons who suffer from mental health conditions and psychosocial disability, because that is a huge topic and we really need to tackle this from a human rights perspective. Thank you.
Thanks, Kieran. I'll just take another question and then I'll return to Claudia and Gerard. Bill Mitchell. Bill, you have
Thank you. Can you hear me now? Sorry about that. Thank you very much to the panelists. It's been very interesting. And this idea of intersectionality and how it fits with ageism, I think is critical to this session's discussions. I just wanted to raise, Jared, I was pleased to hear you say that Indigenous persons are always very much at the forefront of this intersectionality, and they face both age, disability, poverty, and often remoteness as intersecting issues. But also that the importance of autonomy is central to their not only individual but their cultural identity, and also their right to self-determination. And so I just wondered if that was something that we might explore in terms of how it can impact on things like access to justice, and also how access to justice is in fact central to achieving those things. I don't want us to chase that intersectionality tail around too much because it becomes circular, but it's an excellent point. So thank you if you had comments on that.
Okay, thanks a lot, Bill. Claudia, Jared, to you. Who would like to start? Claudia.
Yeah, thank you, Jared, for giving me the floor. And Nina, thanks for the excellent questions. And I knew about the study. Thank you, Laura, to raise awareness once again on your outcomes. And from my perspective, what we always learned about the institutions is the closed club. It's so hard to get into the system, and if there are no procedural mechanisms in the system, it's hard to get access to legal advice. And this is why I try to introduce a kind of specific body for older persons, especially in care homes, to get easier access and also to get legal support in this regard. I think when it comes to systems where they have ombudspersons for older persons, especially for persons in care homes, the access to justice is a little bit easier for them because it's not the judicial system, it's a stage before it, and you get access there, and it's really helpful in this regard. And what you also mentioned is that the missing link to their specific networks in regard of their family and friends and people from the outside, I think this is critical, and it's also key, because if you're part of the systems, and many of the carers are, or care personnel are part of the system, they also don't know where to go if they are witnessing the violation of the human rights of older persons, because it's not part of their ideas how the system works, and they sometimes even don't have access for their own rights. So what we also need to bear in mind in this regard is that it might be useful to also think about how we can strengthen the human rights of the caregivers in one perspective. So it might be easier for them to give support to the person they care for, and make the rights for the person in the care homes available and easy accessible. Because from my perspective, what I very often learn is that especially older persons in institutions and persons with disabilities are not aware of their rights, and they don't get the legal aid to go to court or to go to a lawyer to exercise their rights. But I'm sure that Jared has also some things to add in this regard. And thank you, Bill, also for once again raising awareness to persons with indigenous older persons. I know you raise this issue very often, and I think it's very helpful to get all the examples from Australia and also from other parts of the world. And if it ever comes to the drafting of a new convention, I think this is also a key part of the intersectionality we have to focus on, and then we really rely on your insights in this regard. Thank you.
Thanks, Claudia. Up to you, Jared.
Yeah, thanks for the questions. Really great. Laura, this is something that concerns me greatly, because of course we may make a lot of headway on community living deinstitutionalization for people with disabilities, but still find that the institutionalization industry, let's put it that way, for older people is growing and not shrinking. I don't know if you noticed, but about 6 months ago, our Prime Minister in my country, Ireland, came out publicly and said that we've got to think about the future of long-term care for older people the way we have thought about it for people with disabilities, that is to say, deinstitutionalization. I think he was the first Prime Minister in Europe to explicitly say that on the record. And what's really interesting to me, reading a lot of the policy documents from, for example, the Council of Europe, there's a steady but inexorable trend whereby long-term care is being slowly disassociated from institutional or residential options. And I think that's exactly the right way to go for older people as well as everybody. On the related issue of limitations on rights to sue, I would be fairly confident in saying that would not be consonant with international law. There's probably deals being done in domestic legal orders whereby monies are being poured in, but only on the understanding that private actors would be indemnified against legal suit. I'm not sure how well those deals would stand up, at least with respect to international legal scrutiny. Kieran, very interesting question on mental health. I'd just like to make you aware that the World Health Organization is about to adopt a very, very substantial study on alternatives to coercive approaches for mental health, which of course affect older people as well as people with disabilities. It's one to watch in the field, and I think will contribute to really changing the field into the future. And Bill, your question on indigeneity also touches a raw nerve, because I feel kind of guilty that we didn't do enough in drafting the Disability Treaty to cover that angle. We did have some great Indigenous advocates from New Zealand and from Canada present, but they didn't have the impact that otherwise they should have had. And one of your compatriots, Kelly Johnson, has written a book on culture and the UN CRPD and how it translates differently into, for example, Indigenous cultures. And that's my Bible, one of my Bibles in trying to explore this field. And I would express the hope that if you ever get around to drafting the treaty on older persons, this element of intersectionality, amongst others, would be key to that actual convention. Should I also say I'm fascinated with how indigeneity also spans with other issues like climate change, and with the whole general issue of how you receive general universal norms into very different cultural contexts. So it's important and fascinating at a number of levels. Thank you.
Thanks to both of you. We have one last question from Christina. Christina, please make it brief because we need to slowly wrap up. Christina Raj.
A very good morning to everyone. Am I audible, ma'am? All right, yes. Thank you so much. Well, I just wanted to know, is there any representation, or is ichthyosis considered under the physically challenged category? Because we actually we have severe impediments and we are made to stand in the sun. Wherever we go, we are treated very badly. So I just wanted to know where does it fall? Because in other places, ichthyosis, yes, it is considered and they ensured they listen to us. But here we are just chased away. Thank you.
But sorry, Christina, by here you mean?
I'm sorry, I'm from India. Mm-hmm. All right. Okay. So I'm trying to, even if I go to any court or I want to, I even filed a case online because my property is taken away because of my condition. Now, when I say it's a rare condition, I just cannot visit any offices. So please help me. So nobody just toss me around, or they say, no, it is not in our, it doesn't come under our list. So you please find it. So it's been many years and I don't know what to do and whom to approach.
Jared, do you have any avenues to suggest there?
I mean, the solution under comparative discrimination law and as reflected in the UN CRPD is that if a public service is genuinely not available because, for example, it's hosted out of a historic building, that there would be an alternative way of delivering that service. So it requires a lot more fluidity in the minds of those who plan services and who deliver services. And I would be reasonably comfortable if India has opted into the optional protocol in bringing a test case on.
Thank you so much, sir.
Thank you. Thanks to all of you for these questions. And I'm conscious of the fact that there are also questions in the chat that we have not been able to address at this stage. But this is also points, I think, Claudia and Jared very rightly said that there's a lot more room for reflection, lots more room for improvement when it comes to both the rights of persons with disabilities and the rights of older persons and the intersection between. So this is certainly not an end point, but it is an end point for this side event. And we all have a full day ahead with an open-ended working group session. But before we close, I would just like to give the floor to Claudia and Jared to finish with one takeaway point from today's discussion. Let's start with Claudia.
Thank you, Nina. I think my one takeaway point is that we need to focus more on the intersectionality, especially with indigenous people, and also try to spell it out more closely why do we really need a convention even though we have CRPD. So I think these are the main takeaways from myself. Thank you.
Thanks, Claudia. Certainly very important takeaways. Jared, up to you.
Yeah, I think the centrality of personhood and visibility of persons to me is crucial and something that crosses over the usual identity divides. And I think the main takeaway for me is we have to support each other in pushing forward personhood and visibility because we all benefit by that. And if we don't do that, we all suffer as well.
Thanks, Jared. And if I can add to that, the centrality of rights holders indeed, and the need to involve them in all the discussions about the rights, including the organizations that represent them, I think will be important for all of us in terms of the way forward. So I want to thank all of you who participated in this side event, to thank, of course, the sign language interpreters, the captioners, and all the organizers. There are many of them. And the event recording will be shared on the UN website and the social media accounts of the co-sponsors. Thank you very much for your attention, and I look forward to seeing many of you in other side events and in the UN open-ended working group session. Thanks, everyone. Bye.
Thank you, Nina. Thank you all. Bye.